University in 2008 and cleared UGC NET. He has practiced in various district courts for 4 years. He was selected in judiciary in the batch 2010 and 11. I would like to request Professor Dr. Preet Singh to kindly come forward and felicitate our guest. Thank you, sir. I would like to request Shri Arvind Bansal to address our audience, please.
I would like to request Professor Dr. Preet Singh and Dr. Amit Kumar to kindly come forward and announce the result of the semi-final round of ICMC 2024.
These two teams have qualified for the final round. TC 21, TC 23.
As it is rightly said, in the most prestigious event in the life of a law student, I would like the participants to come and take over their seats for the final round.
Hello, hello, hello. The
Participants, please.
Mr. Counsel and Mr. Legal team from petitioners. So you are representing the Raman company in for both SLPs. In one SLP you are the appellants and in other SLP you are the respondents. And this team is representing SEBI as well as the supplier. That's the thing, na? That's
You're not audible. Come ahead.
Much obliged. The Council seeks permission to do 4. In accordance with Section 15Z of Securities and Exchange Board of India 1992, it's that any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to the Supreme Court within 60 days. The Council seeks permission to start the statement of facts, or if you permit me, can I skip the facts and come to the issues, sir? Sir. TC 23. Answer, can I skip the facts or should I come to the issues? Much obliged. So we will be representing all the 7 cases on behalf of arguments. I will request the judges to please come to the page number 19 or 14th of memorial for the arguments advanced. Shall we start? Much obliged. The first issue is, does SEBA have authority at the Exchange Board of CEO of Lakshmi Incorporation and its director? According to Section 11 of the Security and Exchange Board of India Act 1992, SEBA is entrusted with the responsibilities to regulate security market in India. In the case of Sahara versus SEBI, the Honorable Supreme Court held that SEBA has jurisdiction over a company that makes an offer to the public at large, regardless of whether it is a private or public company. The Council seeks permission to submit the relevant extract of the judgment. Much obliged. So please refer to highlighted one on page number 249, highlighted in blue color. I've given judgment. I've given. So I quote, for exactly the same reason, so as to specify the area expanse of power vested with SEBI under subsection 4 of section 11 of the SEBI Act with reference to clause D, E and F of subsection 4, the legislature likewise limited the authority of SEBI to listed companies or public company which attempt to get their security listed or a recognized stock exchange. I unquote, sir. It is clear that SEBA does not have any authority to investigate companies which are unlisted and have not made any offer to the public. Its jurisdiction primarily covers listed companies to regulate security markets in India. Lakshmi Incorporation is a closely held family firm and its shares are neither listed nor the company has made any offer in the public at large to subscribe to its share. Hence, SEBA has no power to bring any charges against the appellants. The second issue is, can the investigating authority seize the records of Raman and the corporation? It is humbly submitted by the appellants that the investigating authority has no authority under the SEBI Act 1992 to seize the records. Section 11, subsection 2A of SEBI Act states that board may take measure to undertake inspection of record of any listed public company or a public company which intends to get its security listed on any recognized stock exchange. As quoted above, it is pertinent to highlight that SEBA can only undertake this inspection of any listed public company, a public company which is in process of lifting its security in recognized stock exchange. Section 11C, subsection 8 state, where in the course of investigation, the investigating authority has reasonable grounds to believe that the books, records relating to any intermediary or any person associated with security market may be destroyed, mutilated, altered, falsified or secreted. The investigating authority may make any document and record. It is most humbly submitted that in the instant case, SEBA, while seizing the records of Raman, did not take the necessary approval as required under section 11C, subsection 8, thus violating principle of natural justice and has abused its power. SEBI investigating power are extensive but are confined to matter falling within its regulatory mandate.
Counsel, 1 minute.
Yes, sir.
As per your submission and as per page number 15 and 16, are you assuming the jurisdiction of SEBA or not?
No, SEBA is not having the.
But you are arguing the fact that they have not complied with under sections of the SEBI. You have to be firm about that. Understand the point, okay?
Right.
Are we here arguing on the fact that the SEBI has no jurisdiction because it is an unlisted company? That is a separate issue.
Yeah.
But right now, what you are arguing before us is that they have not complied with the certain provisions of Section 11. We are just dealing with broadly Section 11, correct, of SEBI?
Right, sir.
So first you have to make us clear. What are you arguing for?
So SEBI has no jurisdiction regarding this.
And they have also not complied with the certain relevant provisions of SEBI, correct?
Right, sir.
Yeah, please.
First of all, they had no jurisdiction over us since we are not a public listed company, and as my co-counsel just mentioned, we only come under their jurisdiction on 2 counts. Either we are a public listed company, or if we plan to go public in the near future, then only SEBA has jurisdiction over us, which is stated in these sections which she just read out. And the second section, with respect to the seizure, which she was mentioning, here also clearly says that only these, either of these 2 entities you are, then only SEBI can seize your records. Our contention is we were neither, hence they have no ground to seize or no authority to seize our records. They have exceeded their jurisdiction and their mandate. They have exceeded their power. It's an abuse of their power. And neither they approached the judicial magistrate, which is required. They did not even do that. They did not even comply with that. Still they seized our records.
So what is the status of your company? You are a private firm, a partnership firm, a private limited company, a public limited company, a listed company, or what? What are you assuming?
Yeah. If we, I request you to please come to page number 8 of our memorial, which is Lakshmi Corporation is a family-owned corporation by the Raman family. Our position is that we are a public limited company, but we are an unlisted entity.
You are a unlisted entity but a public limited company.
Yes, sir.
And facts, statement of facts, and we say point number 5 that your SEBA observed that the interest of the stakeholders of the corporation was affected to the tune of rupees 500 crore. Yeah?
Yes,
Am I right? How they can be dumped or defrauded by the CEO or other position holders?
sir. In fact, we are contending this as well.
When you are not listed, then who are the other stakeholders apart from your family member?
it says as a company we are always linked to our subsidiary entities. We are a 100-year-old company. We are a big entity. Being limited is, listed is not a mandatory requirement in any.
No, no, it's not a mandatory requirement. I'm just asking, if you are not listed company, you are a public limited company owned by a family firm, and all the positions were held by family members who all were made accused by the SEBA, then holders who have allegedly been defrauded by 500 crore rupees. But apart from you and your family members, who can be the other possible stakeholders without listing it?
Right, sir. Sir, our company is essentially a family-owned entity, as has been mentioned earlier also, and the stakeholders are all within the family. Now, this 500 crore, which SEBA alleges we have, lent to some entities, even if we have lent this amount, we have lent it out to some subsidiary company of ours. That is no crime. Giving any unsecured loans again is not barred in any statute or under the Indian Corporate Indian Companies Act.
I'm just asking, please understand my question. Who can be the possible stakeholders in a public limited company who has not been listed with any stock exchange? Am I clear?
Yes, sir.
So who can be the stakeholders as per the Companies Act in a registered company?
Sir, we are a 100-year-old entity. Over these years,
It can be a family business, it can be a partnership firm, it can be a HAU, Hindu Joint Family Property. But when you are a listed company, when you are a limited company, so who can be the stakeholder in the profit and losses of the company? If someone is contracting you as a supplier or service provider, then he deals with company not as a stakeholder, but as a contractor. Percentage may vary. Stakeholder means the someone who is having stakes in loss or profit of the company.
right, sir. Sir, as far as the ownership of the company is concerned, our intention is the shareholding is with the family members, and some minority shareholding has also been given to our preferred suppliers. Since we have been dealing with them for over 100 years now, so some minority shareholding has been given to them also, and they also own some ownership stake in the company, but still the majority
Listed.
the majority is with the company, with the family itself.
The next point is the Lakshmi Incorporation is closely held family firm of SEBI does not have any jurisdiction, hence any authority to seize the records of Raman and the Lakshmi Incorporation. Our third issue deals with the SEBA investigation and criminal charges against them. It is humbly submitted that the family relationship between the boards of directors with the company's interests. It is humbly told by the Raman family has been in operation for over 100 years, and the directors and senior management who are family members have been carrying out their fiduciary duties to the company and its shareholder diligently in an impartial and unbiased manner. It is humbly stated that directors and senior management of the corporation have been maintaining the highest standard of conduct in their dealing with the company's day-to-day affair as per company's code of conduct, various internal and external regulations, Companies Act according to Companies Act 2013 and corporate governance standards. Our fourth issue is, can the family relationship between the board of directors and senior management of the corporation affect the validity of SEBA investigation and criminal charges against them? It is humbly offered against the director, and the corporate bill cannot be lifted in routine manner unless he is guilty of misfeasance, fraud or acting ultra-vires, and he cannot be made personally liable for the consequences flow. The doctrine has been established for business efficacy, necessity and convenience. It is humbly stated that the criminal charges in the present case are not impartial, are motivated, and the directors and the senior management are being unfairly targeted due to their family connections. It is essential for legal proceedings to focus on evidence and applicable laws rather than family relationships. Sir, Council seeks a permission to call the co-counsel to...
We have some queries from your points.
Yes, sir.
One by one. Since you assumed that the company is not listed, then obviously there is no question of saying that ki SEBI or SEBA has any jurisdiction to interfere, and only the company law tribunal or some regulatory authority of companies act law can intervene. So what regarding your first question, ki does SEBA has the authority? What documents you relied upon to say that your company is not listed or does not come under the jurisdiction of SEBI or SEBA? What possible documents are there in your artery? You can show ki we have come with these documents to fortify your contentions ki that you are not a listed company. What are the documents?
Honorable Lordship, I'd like to draw your attention to again the statement of facts. The point number 2 clearly mentions Lakshmi Incorporation is a family-run corporation that has been in operation for 100 years. The corporation is owned and
Mr. Counsel, you are again not getting my point. A family corporation which is running for last 200 years can also be listed. There is no bar. The facts are silent, whether you are a listed company or not listed company, the facts are totally silent. Since you are representing the petitioner or the appellant, you are assuming that your company is not listed. You are assuming this because the facts are vague and silent. We are saying ki what documents you are relying upon to fortify your contentions that you are not a listed company, rather a public limited company who is not intended to be listed and not listed yet with SEBI or any stock exchange. So what documents, I am just asking your knowledge, ki what,
memorandum of association
yeah.
clearly states that we are going to be unlisted, and these documents prove that we are an unlisted public limited company. We have the ROC certificate as well with us, wherein the date of incorporation, the fact of our incorporation, all that is available. It also clearly points out the status as which we are contending is true and correct. So these are the documents which we will primarily rely on to substantiate our claim or to back our claim.
Any other document besides this article of association, memorandum of association, and
there is also the shareholding register we have, which again also shows the fact that our shareholding is completely within the family, or the slight minority shareholding which we have shared with some preferred suppliers.
now coming to the second question. You say that assuming that SEBI has the authority, but still SEBI has not acted in accordance with the provisions of the Act. They have seized your documents and account books without following the procedure established in Section 11, Clause 4. It's your contention. So, can you elaborate if there is any deviation from the procedure established under the Special Act? Suppose the SEBI has not followed that provision strictly, so whether any material illegality has been caused by not following these procedures, or the failure to follow these procedures only causes some mere irregularities which can be cured in the larger sense. They have acted to stop a big fraud with suppose you are a listed company, suppose that's why we are assuming that SEBI has acted upon just to stop the fraud with some common shareholders, you can say. What is the nature of this?
Sir, the effect cannot be cured. As we pointed out, as my co-counsel just mentioned,
The point to distinguish the procedural lacuna is mere irregularity or illegality. What is the core point? What is the law to differentiate if it causes irregularity or illegality?
sir, my co-counsel just mentioned and pointed out Section 11C, subsection 8 of the SEBI Act, which states that to seize any such records, the investigating authority has to make an application to the judicial magistrate of the first class.
I agree with your point. Yes, they have not followed the point. You are saying that you assumed that they have not applied with the magistrate and have not followed the procedure before seizing and confiscating your account books. They have committed that procedural irregularity. So how can you take it as illegality which goes to the root of the case and vitiates everything? I am throwing you a question. Yes, it's a lacuna on their part, but it's an irregularity. It can be cured. What prejudice has been caused to you?
So I beg to differ. I don't think this lacuna can be cured. We had to approach the Honorable Judicial Magistrate and then only seize our records. They have clearly gone beyond the law, what they are permitted to do under the law. And to my mind, I don't think this basic flaw can be cured at a later stage.
It's not about opinion. Convince us कि yes, it caused a serious prejudice to you that has actually vitiated your natural rights, natural law justice, and just goes to the root of the case. How can you say? मतलब, I am just asking what is the difference and how you determine, how you come to the conclusion that it's not mere irregularity, rather an illegality.
Sir, I'm getting the question you are asking. I don't think they've really followed any, any statutory provisions as would be required under any law. It could be neither procedures, the statutory provisions under the criminal procedure code have been followed here. They require two witnesses, independent witnesses. In fact, if they have to carry out such as...
Yes, now you are coming to the point. The purpose of providing this procedure, the safeguard for applying before the magistrate, is just to bring transparency in the entire process. And if there is no transparency, then you can say that the possibility of manipulation is there.
Yes, sir. So exactly this is what they did. They did not bring any independent witnesses there. Neither was this, neither we were there. This vitiates the entire,
Ram, regarding the third point, you have submitted your submission. So, what do you mean by the conflict of interest? And how conflict of interest can be there when the company is held by a close family members, having no outsiders to have any stakes? So, how can there be a conflict of interest?
So conflict of interest is between,
What is the conflict of interest?
So conflict of interest is like whether you are giving importance to the family ties. Sir, as stated in the Black Law Dictionary, conflict of interest is a situation where personal interest clashes with professional responsibilities, potentially undermining impartiality. Means like if there is a clash between companies and between the company and the family, so it's a duty of the director and the CEO that it should give importance to the company's interest. It's not the family interest come first, it's the company's interest come first.
Coming to the main aspect of Section 11 as we were talking about, let's concentrate on Section 11 of SEBI first. That will answer all to the query once for all. What does Section 11 says? Yeah. Let us speak. You can assist her. Come, assist her. We'll squarely cover to Section 11 and then to your proposition with... Yes.
Section 11 broadly talks about the powers of SEBI.
Okay.
Conduct investigations if there are any irregularities in the securities market.
Correct. So there is an allegation of 500 crores, correct?
Yeah, there is an allegation.
We're taking into that aspect as well. There is a section. So it has power to act upon it. What is the harm?
No, sir, it has only power to act if we are under their jurisdiction. We are not under their jurisdiction. One, if we are a public listed company.
Where it is written in your paper book?
This is, sir, if you refer to section 11(2)(a), I'll point out the exact, it's
Page number 15. 15.
Point B.
Yes, read it.
Section.
Yes.
Or a public company which intends to get its securities listed on the security exchange or stock exchange.
Document that is required. Don't start with ROC and that you have already answered. What is the document that shows that anyone sitting over here that can show that a company is listed or not?
Sir, a listed company is obviously...
Counsel, listen. My question is very simple. There is just one document that says it all.
Yeah, if our share certificate, it's a demand form.
It's not that.
And if we are listed on a stock exchange, then only we are a listed company.
Carry on. Let's go ahead. You.
So mic move on, sir. Sorry, sir. Yeah, so he'll come.
I'll take your permission to oppose the tax.
Yeah, please.
Sir, the Council seeks permission to proceed with the statement of jurisdiction for issues 5 to 7. In accordance with Article 136 of the Constitution, read with Order 22, Rule 8 of the Supreme Court Rules 2013, the appellants have approached the Honorable Supreme Court. Article 136 states that the SC may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed by any court or tribunal. Thus, the appellants have approached the Honorable Court by filing an appeal under this Article 136 for adjudicating this matter. Sir, I will now move to the issues number, if you may grant your permission. In fact, the exhaustive written arguments have been already advanced in the memorial. I will be limiting myself to the oral arguments and highlight few select key points. Yeah. Okay, sir. I'll just read out the issue number 5. Sir, it says whether Raman, as his role as CEO of Lakshmi Incorporation, and the directors have breached the contract with this supplier by disclosing the confidential information. Sir, most humbly, we have not breached the contract. The breach of contract, the definition or the literal meaning is the failure of either party to a contract to perform his or her obligations under a contract. It is brought before this honorable court that Raman and other directors did enter into this contract. It is humbly accepted that this contract did contain a confidentiality clause. However, confidentiality is not absolute. There are exceptional conditions wherein disclosure of confidential information would not amount to breach of contract. Exceptions and differences to disclosing confidential information in a contract, thereby avoiding it being considered a breach, include a legal obligation to disclose or release the confidential information, such as complying with a regulatory requirement or the ruling of a regulatory authority. Now I'll point out that this action has been taken by SEBI. SEBI under section 11, subsection 3, has the same powers as are vested in a civil code. And under this particular subsection, they have the power to order or production of any document, apart from the other powers which are there in the civil code. Thus, they obligated my company to disclose this information to SEBI. Now, we could not, perform our contractual obligation of not disclosing the confidential information because of factors which were beyond our control. A judgment. In fact, if you refer to the highlighted text on page 11, paragraph 27, and I quote from the judgment, it's highlighted, sir, it's on page 11 and paragraph 27. A breach of it therefore gives a claim for nominal damages or for qualified subject to certain reasonable, if not essential exceptions. The instances are the duty to obey an order under the Bankers Book Evidence Act. Now I'll just briefly point out the case, the issue which was dealt in this case. In this case, the Honorable Calcutta High Court referred to the Halsbury's laws of England, and it said that it's an implied term of contract between a banker and his customer. This actually case relates to a banker and a customer, that the banker will not divulge to third persons without the consent, express or implied, of the customer, either on account of this relationship. Unless, it says, unless the banker is compelled to do so by order of a court, or the circumstances give rise to a public duty of disclosure, or the protection of the banker's own interest requires. In this instant case, SEBA, as I pointed out, has the powers, and in fact, our contention is they abuse those powers, and they seize the records. So there is obviously no breach which has been done willfully, neither was there any mens rea on our part. again in this ruling, the court even fact had further observed that the duties of the bankers may be reckoned as the duty of secrecy also to the customer. Such duty is a legal one arising out of the contract and is not merely a moral one. Breach of it, therefore, there is exceptions, which I just pointed out, and the exception in this case or in this order was accepted that if there is an order of a regulatory authority, it's considered a valid exception. So hence, there's another case of Z Telephones Limited versus Sundial Communications, in which the court had held that to constitute a breach, it has to be established that unauthorized use of funds.
Now
So
come to
here,
the-
just small thing. The suppliers incorporation has not suffered any loss because of this breach. It has been only shared with the regulatory authority, and they are going overboard by assuming that the SEBA will make some commercial use out of it.
They have not claimed anything.
So they have. Why are they here otherwise? They are. They
No,
went
no, no,
to
no,
the
no, no,
lower
no, no,
court.
no. Understand my question first. Have they asked anything, in forms of damages? Have they asked anything? Because otherwise the point is very much clear. You have sufficient on that.
Okay.
There's no need to make the such kind of arguments.
Right, sir. So this breach. So may I be allowed some more time? Okay. Thank you, sir. So should I proceed to the point 6 or 7, or you mentioned? So should I specifically address the point 6 or 7 because they are a consequence of this breach?
Yeah. Point 6, you have just submitted your submissions regarding confidentiality clause. Now come to the non-compete clause. What is this?
Sir, the non-compete clause, even though it's not really relevant, I mean, because we might have admitted to this, but we are not competing with them. It essentially means that we will not tomorrow set up a, similar kind of operation which our supplier is doing. So that is something we had agreed to, and but in the non-compete clause also there is a very specific, provision or requirement, and this I'll point out is mentioned in section 27 of the Indian Contract Act, which says that any agreement which is in restraint of trade is void. So employment for me, that is in fact affecting my fundamental rights, and
So
they cannot
then
be
you
allowed to do that.
are suggesting that non-compete clause is totally illegal and cannot be enforced at all as per section 27 of Indian Contract Act, or is there an exception?
So the-
Or what is the purpose and what is the relationship between this confidentiality clause and non-compete clause? How can you cope up with these both two terms?
Well, it's difficult to draw a direct correlation, but the suppliers incorporation might have felt some concern that it could be that we might tomorrow get into their business activity.
Actually, the confidentiality clause is there. They are supplying you some information, some technical information
Right, sir.
that shall not be shared with anyone. So that there, you can say the copyright, the trademark, the intellectual property inherited in that in that information shall not be disclosed to anyone. A business which can be run on the basis of those confidentiality protected information.
Right, sir.
So when you statutorily under the you are saying that you have been compelled by the statutory authority to disclose those information, then it comes in the public domain, or at least in the close circle of your family. First of all, my question is that yes, you are saying that you have been compelled by the statutory authority, SEBI, and you have an excuse to that. When you are fighting for your rights, omission also amount to act. When you fail to act, it also amounts to acting. Clause, privilege clause, yes, this information shall be taken by the SEBI only in sealed cover, or shall not be disclosed in the court, shall not be put in domain, just to protect the interest of your supplier, with whom you have made a contract. What steps you have taken to protect his rights? Only except to take the shelter under the umbrella of statutory exception. Why your omission shall not be amount to act, and your failure to take the defense of privilege?
So first of all, our omission is not deliberate. Secondly, as I pointed out, there is no mens rea on our part. there was no criminal intent on our part, wherein you know there might be some limited failure, but that we've already challenged, wherein we have said that SEBA exceeded their mandate and they seized our records, but we could not have physically prevented them from doing what they did. They simply seized the records. As the fact also says, it's not that we disclosed this information to them. They simply came and seized the records. There was no way we could have physically stopped.
I am just saying what safeguards you have taken to protect the confidentiality of that information. What safeguards have you taken? You are supposed to do at least something to protect that confidentiality. You should have raised objections. You might have put those records in some sealed cover and submit those records with SEBA with some objections under protest, under confidentiality, under objections. Ki yes, once you are challenging their jurisdiction, active actions have been taken by you to honor that clause.
Sir, in fact, we did all of that. We not only, gave them this in seal, we tried to, ensure that when they were seizing the records, all of the records are put in a sealed cover. To the extent it was permitted to us or the time allowed, we carried out this activity. And we also, in fact, had mentioned to them, we suggested this to them, that they can, take samples or copies or, take evidence, reproduction of that record, and they can carry it with them while we'll retain the originals with us. So we did, try to the extent possible within those circumstances to do it. But again, had we physically resisted, it would have been, I think, a serious criminal, outcome.
You were here before us in 136. You could have easily gone to 226 and 227 before the Honorable High Court.
Yeah, but then the outcome would have still been the same, sir, because they would have still seized those records. Should I make the concluding remarks or?
Please. Make.
Your Lordship, with respect to the legal proceedings, it is often said that the process itself becomes punishment. And this CJI, in my concluding oral arguments, I would most humbly submit to the Honorable Court to not allow this to happen in this present case, wherein malicious and motivated proceedings have been launched against my client, which would undoubtedly cripple a successful, reputed 100-year-old corporate entity. In the light of the facts stated and the issues raised, it is most humbly prayed that the Honorable Court may be pleased to adjudge and declare that the first order of SEBA dated 21st December be set aside, 21st December 2022, that the insider trading charges brought by SEBA be set aside. In fact, the insider trading charges have been separately, we have appealed those charges in a separate court, and that appeal is also pending. I just wanted to bring this out in front of this.
Okay.
Thank you, sir. Thank you.
My Lordships, may I take the permission? Okay. Okay, basically this is a and others which the respondent, that is we as SEBA, are responding to it. And the other is between supply under Article 136 of the Constitution for Lakshmi Corporation. It's an SLP which we have filed under Article 136 of the Constitution of Oman with Order 22, Rule 8 of the Supreme Court Rules 2013. The appellants, Lakshmi Corporation, have approached the Honorable Supreme Court of Oman to question the decision of the Honorable High Court. Article 136 of the Constitution to appeal.
Counsel, where are you? On which page?
I am on Statement of Jurisdiction, page 1.
Please go ahead.
Nothing in clause 1 shall apply to any judgment, determination, sentence or order passed or made by 2013 provides that on the granting of the special leave, the petition for special leave shall be treated as a petition of appeal and shall be registered and numbered as such. the SEBA and others have approached the Honorable Supreme Court for adjudicating the matter brought forth in the court of law. Okay. So you want me to start with the issues, my lordship? Okay. So in arguments advanced, we have 4 issues. 2 issues will be dealt by me and 2 issues will be dealt by my co-counsel Satnam. So I am starting with the first issue. The given appeal against the High Court judgment is not maintainable in Lakshmi Corporation vs. SEBA and others. It is respectfully submitted before the Honorable Supreme Court hereinafter as SC that the appeal petition filed by Lakshmi Corporation under Article 136 of the Constitution of Amman hereinafter as Constitution is not maintainable on the grounds that there is no special reason for entertaining this appeal petition and there has been no substantial and grave injustice done in the present matter. Questions of facts cannot be ordinarily entertained in an appeal, therefore the appeal cannot be subject to special leave as there is lack of special circumstances. Present petition is not maintainable. It is humbly submitted to this honorable court that the remedy of as contemplated under Article 136 must be exercised in exceptional situations. It is settled that if the SC starts entertaining all and sundry kind of cases, it will soon be flooded with a huge amount of backlog and will not be able to deal with important questions relating to the Constitution or the law, or where grave injustice has been. Standard to avert this is that the discretion of SC under Article 136 must be exercised judiciously in exceptional cases only, and that its power must be self-checked. Moreover, the SC is the final arbitrator, but only when the dispute needs to be settled by the apex court so as to avoid injustice and infraction of law. And when there is no such infraction, what really matters is whether the finding is manifestly unreasonable and unjust in the context of evidence on record. It is well established that this honorable court does not by special leave convert itself into a court to review evidence for the third time. Where, however, the court below fails in apprehending the true effect of a material change in the versions given by the witnesses immediately after the occurrence and the narrative at the trial with respect to
Counsel, we are not getting anything. What you are addressing, what you are, where you want to.
We are trying to convey to your lordship that here the appeal is not maintainable, and the appeal which has been made by
Whose appeal?
Rather, the appeal is
By that Lakshmi.
not the suppliers. Lakshmi Corporation has made an appeal against
yeah,
SEBA and
against-
others. That there are the findings of High Court, SAT and SEBA of Amman in Lakshmi Corporation vs. SEBA and others. In that, SEBA and others has found Lakshmi Corporation liable for insider trading, which they conducted, and it has not been proved with certainty by our counterparts that whether Lakshmi Corporation, that is the point of contention, and at that, Lakshmi Corporation did insider trading and they fall under the jurisdiction of SEBA. They are really a publicly listed company.
Is that insider trading?
Insider trading is basically when we try to buy shares or sell shares based on some prior information, whether the price of those shares is going to be controlled or altered, and whether we may get some undue profit by that piece of information from the purchased shares. If the price is going to fluctuate and it's going to rise, we may buy shares. If the price is going to fall, then we may sell shares to avoid loss in the market based on the prior information.
What are the safeguards expected to be exercised by the company owners or promoters?
Excuse me, I didn't get the question. Would you please repeat?
What are the statutory safeguards? What are the procedure for the stakeholders or promoter of a listed company to buy or purchase shares, their company share, to avoid inside trading? How can they avoid, and what safeguards they fail to adhere with? How it comes to the insider, what procedures they have not followed to bring their action of selling or buying their own company share.
It's already known in the market.
But is the price going to they have not well prior they have not furnished the prior information with the necessary authorities. That's why it comes into the category of inside trading.
Then the third issue is going to be.
Thank you. Your Lordship, am I audible? Am I audible, Your Lordships?
So, first deal with the issues. We are not clear out. You have just come, read with the paperwork and gone. We are satisfied with our jurisdiction. We don't need to know the power from you, but you have to satisfy us first. He has said that it is a contention, it is a government, that it is not listed. Prove it. If it is a listed company, how? What documents have you filed before us to prove that it is a listed company?
Yes. So, Your Lordship, if you see the statement of facts.
Because if we come to your page, book number 11, you yourself are in dispute with accompanying with the fact that the SEBI is the actual authority, because you yourself are admitting to the SFI authority. Please come to page number 17.
Page number 17.
When we come to the embezzlement of funds, you have referred to SFIO.
Okay, on page number 17.
Who bring the charges against Ramano? You yourself are disputing the jurisdiction of SAB. So section 11 comes out of the big. Page number 11, sorry, page number 11.
Page number 11.
Yes. What do you want? If it is fine, then their contentions are proven. If you yourself are independent.
Which particular point you are referring to on page number 11?
Does the CB have the authority to the other questions, bringing charge against Raman in connection with the rule as a CEO of Lakshmi?
Okay, these are some of the issues which we have highlighted, or questions of law which we have not highlighted. These are other questions which are pertaining to what was mentioned in the proposition. So these are just the answers to those questions. These are not questions which are relating to any particular plaintiff or respondent from our perspective, petitioner or respondent. These are generic questions which were there in the proposition.
I agree, we both are on the same page. We are on the same page. I have one simple question. You are saying it is not listed company. My question to you is, prove that it is a listed company.
Yes. So, on proving, on coming to that point, Your Lordship.
This information is not available in the facts of the case. And it goes beyond.
I'll rephrase my question for you. Then how can we know that a company is listed or not? I'll rephrase it for you. If it is silent on the facts, then tell me how can we know that a company is listed or not?
We are just asking what documents you are relying upon to prove your contention, to substantiate your contention that it's a listed company, comes under your jurisdiction. What are the documents you are relying upon that they have committed the offense of embezzlement and committed the wrongs of inside trading? What are the documents, possible documents you are relying upon?
Yes, Your Lordship, we can also contact the stock exchanges of Oman, where the stocks are listed for publicly listed.
Have you done that?
Yes, we have done that.
Where is it?
Have you brought the list of listed companies from the stock exchange?
Or MC record?
Yes, we have.
Where is it? Shows.
So, I mean, this is going as per the facts of the case.
Go ahead.
So, here we are assuming that we have contacted the stock exchanges to find out whether it's a listed company in the stock exchange or not. And we got the answers and information. So it's a
Yes.
listed.
Okay. Go ahead.
So it comes under the jurisdiction of CBI.
Go ahead.
So, the majority of the directors. It doesn't say all the directors are the family members. So, definitely there is some loophole in the fact which we have found out by cross-verifying against the authorities, and found out that it's a listed company, and the statement made by my counsel is false to misguide the court, right? Because again, it is they clarify and satisfy whether the company they are talking about or claiming that it is not publicly listed. However, we are contending that because the statements, as I am maybe repeating that all the directors are not the family members, investors who might not, who are hidden because since they are not disclosed to us. So SEBA does have the authority to investigate that who those investors are, and it is the duty as per section 11C, SEBA's duty to protect the interests of the investors, and it is quite evident from our findings in 2019 that we have found Raman, who is a habitual offender, and in 2019 we have found certain facts about where we have held liable the Raman, who is the CEO of the company. We have held him liable and we have fined him. So the Raman here is trying to hide behind the garb of the organization and claiming that it's a
Mr. Counsel, let me ask you a question. Because the entire case is going on assumptions and presumptions. You are assuming facts in your favor, they are assuming facts in their favor. That's okay. That's okay. Now, the real content, procedural aspect as well as the substantial aspect. For procedural aspects, I can ask you what can be the possible, or Mr. Raman, what are the possible documentations to consult with to come to the conclusion that Mr. Raman has committed the.
Your Lordship, in this case, Mr. Raman's and the company's accounts and the director's accounts were seized and they were frozen, and they were audited, and auditing was done. So, all actions which was done by the company, and already been seen in the findings that 5 investments which are questionable. So, on the basis of that, this was found out. Although we do agree that SEBA did not have true conscience. If SEBA and if SEBA initiated that was out of its jurisdiction, and the Lordship, definitely we feel that we feel sorry for that, and we want to apologize for that it went out of its jurisdiction. But at the same time, it also did this in the interest of justice, equity, and due conscience.
So I would like to rephrase. I mean, we were investigating Lakshmi INC and the group CEO Raman for the interest of the investors to see if he is feeling it. Right? This was found during our investigation. But the other charge that the Raman has been held for, that he has also the funds that he gathered from, he has transferred it to the other offshore accounts which we couldn't trace, and he has yet not proved that from where that money came from and where did it go. The next contention is that the Raman and company has failed us to provide whether he has, while giving those loans, whether he got an approval from their board members or not. These documents were not produced by him, whether he has the vote from all their board members of their family.
You should have consulted. Your co-counsel has just apologized before this honorable court that SEBI has gone beyond his jurisdiction.
So what
how can you say?
He meant is that during investigation by SEBI also found embezzlement. Though embezzlement doesn't find, come under the jurisdiction of SEBA, so we have notified the embezzlement action to the other concerned authorities like SFI. Yeah, so this is one piece. The other
Contract. So the other issue is the suppliers limited versus
the suppliers limited. The suppliers limited and election.
so which there is conflict of interest is something we have answered this also in our memorial. The CEO and the board of directors have all agreed in unison in the Apex Code denying the charges against themselves. Raman is the head of the family and CEO.
Counsel, page.
Page number 11. Page 11.
Serial number 7.
The CEO and board of directors have all applied in unison in the Apex Code denying the charges against themselves. Raman is the head of the family and CEO who will be acting on behalf of the family and taking decisions. So it may be possible that the accusations against Raman and his family are false. The accusations against Raman and Raman may be true, but may be false against his family recognition against Raman and some of the family members may be true, but false against other family members. Raman and the entire family are indebted together. Thus, there is a possibility of conflict of interest.
What can be the conflict of interest in this proposition? Can a family, a head of a family, not be a CEO of a family business run like this Lakshmi Corporation, which may be a listed company? So how can you say the head of the family being the CEO, there is a conflict of interest? If the company is established by the family, obviously it is to be led by any member of the family only. If Tata Group is led by Ratan Tata, then how you can say Ratan Tata and the Tata Group has a conflict of interest?
So, Your Lordship, if you see the structure of the Lakshmi INC board, so Raman is head of a family, and majority of the board members are the family, right? Now, since Raman is working in the capacity of the CEO as well as he is the head of the family, so he can pass certain information, right? To their, in the capacity of a family members, he can pass certain information to the board members who are also the family members of Raman.
You are just suggesting that if business where run by a family, the members of the family cannot be the board members or the director or the CEO, otherwise it will be a conflict of interest. Like Reliance Company, Jio Company, Mr.
Your Lordship, here the possibility is that when
Then that's why I am asking what is conflict of interest in your terminology.
yes. So Your Lordship, here what it could imply is that if Raman and some of this being family members, being close to each other, knowing each other very well, and they could take a stand with some secret understanding and then deny the charges.
So you are just stressing
and
that
falsify the charges.
you are just stressing that charge of conflict of interest only to have a fair investigation. You are suggesting that the conflict of interest may hamper the fair investigation.
Yes. It should be a fair investigation and impartial.
Now come to the confidential clause in that.
So, for the confidentiality clause, which are Lakshmi INC behind the bar of SEBA, though he has explicitly colluded with the family members and have breached the confidentiality and the non-compete clause by
Council, here we are. When we talk about damages, are we talking about actual damages or we are apprehending there might be a confidentiality clause that has been disclosed before a concerned government authority? So are we here apprehending or some actual damages has already been caused?
So we are saying that the damage shield of the has between us by the actions of the Raman and INC in colluding with the family members is breach of confidentiality and the non-compete clause because we are suffering business loss with them. And they are also partnering and coaching our clients as well to contracts they have signed. So, we would like to contribute with the prayer. So, in the light of facts stated, issues raised, arguments advanced, and authorities cited, SEBA and others along with the Suppliers Limited humbly submit that the Honorable Court may be pleased to adjudge the declared SEBA and others are justified to protecting the interests of the investors, and investors must be compensated with the payment of damages worth 600 crores. The Suppliers Limited are at a loss account of confidentiality breach in their contract with Lakshmi INC and maybe. So we have been giving as per since the SEBA has the equivalent as per section, they failed to respond us back on timely.
Laid down in the documents.
Yes.
Something of the confidentiality breach part. In the confidentiality breach was given. We have already Thank you. Thank you very much.
First of all, I should be thankful to my dear council who has made my job easier by getting that SEBA, went beyond their jurisdiction. In fact, on this very count itself, my client stands vindicated. and the whole case rests there. Other than the other many procedural mistakes which they were admitted. So, right. Thank you.
Both happen. What is never acceptable is quitting. As we all know that you have gathered here for the most prestigious event in the life of a law student, I would like to take the privilege to welcome all of you to the valedictory ceremony of India College Moot Competition 2024 organized by MERI Professional and Law Institute.
I request Ms. Sudhita Malkaran to kindly come forward for the certificate distribution ceremony.
On behalf of the MERI family, first of all, I would like to thank the judges for spending their time. And yes, so for now, from here on, we need to distribute some certificates to request the judges to please come forward. Do we have Akriti from BBLLB? Sakshi from BBLB. From BBLB. Ms. Anshika Garg, BBLB. Mr. Nishchay Chadha. Akash Kumar Tiwari. Can we have a round of applause, please? Mr.